Big poppin', money in the bank, coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me big poppin'. Money in the bank, coming, dropping a deposit. Having it my way, so I got these bitches watching. Steady getting to it, couldn't fit it in my pocket. Flexing everything, baby, tell me what the top is.
What's poppin', everybody? It's your favorite doc tender, that girl Henny, and I'm here to pour up plenty of the updates on the Diddy court docs for you. Now, if you are new here, please be sure to like, comment, and of course subscribe. Click the notification bell, select all, so you get notified whenever I do a video. And if you are a returning Mob Down Henny Gang member, yeah, we about to pour up on this content. But first, let me fix my screen because I don't like this. And I don't like that color. Now, I'll go disco Barbie on y'all a little later on. But let me make sure my mic is on because y'all know, nope, it ain't the right mic. Bloop. There we go. Now we should hear a little bit better. Okay, it should be a little bit better for you guys. I hope everybody is feeling good on this F-It Friday, taking a page out of Diddy's book because that's what he called them, F-It Fridays, F-It Fridays. So we're going to have an F-It Friday, and let me tell you what F-It Fridays are going to consist of here on the channel. So during the spiked coffee or the late night pour up, whichever one that it is that I'm on, or during the rush hour, I don't know. But those are 3 times that you could possibly catch me live. But during Fridays, we're not putting anyone out of the chat. No. I'm going to let y'all rag, tag, and drag whoever comes in the comment section on some BS. Y'all like that? Henny glasses in the chat if y'all like that idea. Because I figure after a long work week, people have a lot of tension to get off of their chest. People being you, people being me. Now, I promise that I will do my best to continue to stay on topic. But on Fridays, y'all get to go ahead and catch y'all wreck. Because I know that sometimes y'all hate when people come in here and start disturbing the conversation. And I know sometimes y'all be upset because y'all be wanting to go in on them and drag the way that the Henny Gang drags, okay? And the mods, the bodyguards, the snipers, whichever one you want to call them, bouncers, the bouncers and the snipers be in here getting them up out of here before y'all can catch y'all wreck. So I just figure I'll go ahead and I'll let you guys have that on Fridays all day, no matter which live it is. That means that if it's over here, that means if it's on Circus Press Box, it doesn't matter. It doesn't matter. It's F-It Friday. Let my mods have a break a little bit. Now if they get a little too egregious and disrespectful, then they got to go. But other than that, you guys have free range. Anyway, top of the top to everybody. Welcome back to Spike Coffee in the Morning. I didn't say that to y'all yesterday. Now, I did set this, and I know I said that I was going to go at 10 and 10, but it seems like when I said 10 and 10, people want to go at 10 o'clock. So I said, let me go at 9:30. 9 o'clock yesterday, I went live. Nobody was live. I go live this morning. It is what it is. So we are going to continue to do what we do over here. And what I have for y'all today, if y'all remember yesterday, we got into the defense's newest filing that they put in. Now, if you remember on the 29th, they filed for a bail offer, okay? And they offered $50 million, electronic monitoring. They even offered private security that would personally keep an eye on Diddy, assuring that he stays in his 2-star island mansion, doesn't go anywhere, doesn't have contact with anyone. And that was the offer that was placed on the table. But all of that still sounds very familiar to what they've been offering. They even said that someone else would post a cosign for the bond. And so the judge had already denied that. And if you remember when we went over that video, I explained to y'all and broke down through the transcript what the judge had to say about the bail hearing and why he was denying it. Okay. Now we fast forward to the 30th, which was a day before yesterday. Before the stroke of midnight, the defense put in a motion for either a Rule 29 or a Rule 33. Now, if you forgot what that means or you missed that portion, a Rule 29 motion is moving for an acquittal, which is something that they already had attempted to do during the trial. And the judge did reserve or hold on that because he was going to wait. Now, I said that when it first came out, the judge could either rule right there for an acquittal, or he could say, listen, I'm going to hold until the jury gives their their determination, their verdict, excuse me, on the situation, and then answer whether or not he was going to do the Rule 29. When, like I told you, I think the Rule 29 kind of got lost in the shuffle because as soon as the verdict came in, the first thing that happened was they moved for a bail. Now they asked for it again. Normally there's 14 days for the Rule 29 to be able to be used after a verdict comes in. But I think because they did that Rule 29 during the trial, that gave them time thereafter. Now, I'm not sure. Don't quote me on that. But that could be something that the judge does have to consider. Also, they moved for a Rule 33. And in the Rule 33, it's basically saying that there wasn't sufficient evidence against Diddy when it came down to the Mann Act. Because remember, even though people are saying Diddy is innocent, Diddy is not guilty, he was found guilty of 2 counts of the Mann Act, you guys. So there's still 2 federal counts of the Mann Act, I might add, that he is facing right now as far as sentencing. And so they're saying there wasn't sufficient evidence to back up the Mann Act counts that he did receive. And they're also saying that, listen, no one else, they put a whole list of cases there. Okay. Child, it was a lot of cases that they did. All right. Where it showed similar, but not exactly like Diddy's cases where people were let go on bail. All right. Or they were ROR'd, which is released on their own recognizances. But yeah, so that's that. And then I also talked about the judge's charges, the way that the jury was able to come to that conclusion. I explained all of that to you because at the end of the day, a lot of the technicalities of things are being missed in the conversations. So I wanted to make sure that I gave y'all that because, child, we're not going to be over here dizzy just because this the bar. That don't mean that we be getting drunk and losing our minds over here, child. We still got to be a little educated. So now, when I went live yesterday, I told you guys that the government had not responded and that the Judge Arun Subramanian, gave the government until the 31st to be able to file. Well, guess what? Last night at about 11 something at night, if I'm not mistaken, maybe a little after 12, I can't really recall the time it was, but I decided to hit up Henny Legal because all day long, now if you remember, it was Apple Juice's birthday, child. And so all day long, I kept like texting, like, still nothing from the government? Still nothing, because I can't check it because I'm busy. Like, you know what I'm saying? So I'm like, still nothing from the government? And they're like, no. And I'm like, what the hell is going on? Like, are they giving up? Are they conceding? Like, what is going on? Because if you remember, I also told you that when Maureen Comey got fired, remember that video? If you don't remember that video, go watch it. Okay. I told y'all that Maureen Comey, she got fired and that Jay Clayton was already there, like kind of like interning or whatever, but that he was a Trump appointee. I told y'all that. And I told y'all that I thought that he was going to step in place of Maureen Comey. And child, it looks like that's what he did. Because before or after the stroke of midnight, let me give y'all accuracy, okay? Because y'all know I don't usually play with y'all like this. So let me go ahead and let me give y'all the accuracy on when this actually get 11:39 p.m. is when I got it. Okay, so that means like around 11:30 or something like that. They filed their response to the government's bail. And baby, I was reading it. I was like, oh. Now, I know people are not going to be able to come out here and tell y'all that they was sitting there like, oh, listen, when I tell you, this is why I said the defense and the government, it's Clash of the Titans, baby. It's a battle, okay? Even when they was giving their closing arguments, honey, I'm not going to lie to you. I was like, oh. And then, when the other party got up, I'm like, Oh, like y'all know, because I was telling y'all, baby, the defense, they came in, they came in hot on that one. The government said this, and the defense came in like this. But the government got to come back. Let's see if they clap back. And sure enough, it will be a clap back. So it's no different. And Mr. J. Clayton is not missing a beat when it comes down to this. Baby, let me tell you, I am enjoying the back and forth between the defense and the prosecution. If I'm going to be completely honest with y'all, I'm loving it, okay? Because, child, let me just stop talking and let me just get the document up on the screen for y'all because, baby, let me tell you. Where is it? No, I got it. I got it open. Hold on. Child, I gotta put my glasses on. Matter of fact, let me see how this looks in this window for y'all. And I'm gonna put some music on as well. Okay, we can do that. We can do this. I like this. I like this better for us because then y'all can see somewhat because I'm about to put the watermark over it. Matter of fact, I ain't putting no damn watermark over it. I don't even care. Okay, if somebody want to steal it, y'all gonna steal it regardless. So or whatever. Let's get into it. Let me get my glasses on. Now, don't y'all come messing with me because I told y'all I done messed up my glasses, all right? I done broke them, all right? But they still sit on my face and sit on my face. Well, they do. So now let's get into this, baby, because this is some hot Henny. Meanwhile, I see y'all scrolling up on the screen. Give me a minute. Let me just, before we do that, let me just say, what's poppin' Miss Pammy? What's poppin' Xavier? What's poppin' Miss Teddy B? What's poppin' Yvette? What's poppin' I'm all smiles? What's poppin' Lady T on her square biz? What's poppin' She got to be more careful? What's poppin' Moonlight Sunshine? What's poppin' Goddess with the edits? What's poppin' Zoe? What's poppin' Nino Black? What's poppin' Stanford Mom? What's poppin' Debony? What's poppin' Gina? What's poppin' M King? What's poppin' God bless? Who else is up in here? Zaire, I can't say the first part, but what's poppin' Zaire? What's poppin' Miss Shaw is up in here. What's poppin' Venus? What's poppin' Bree Bree? What's poppin' M Mac? What's poppin' Faye? What's poppin' It's Just Me? Shauna D. What's poppin', Nikki? I don't know how to say your name, but what's poppin' to you as well? Judge gave them until 30th of July to submit post-verdict motions. They are fine. They gave them till the 31st, honestly, but yeah, they did do it in now. What did you say? Jay Clayton always has his name on government motions even before trial. Nothing changed yet, but what's changed is he's taken over this case. That's the thing that's changed. What's poppin' Swagger Low? What's poppin' Zamoni? Did I say that right? Let me know if I said that right. All right. So now that I've said what's popping to people, let you know if you in the bushes, because I see the numbers. And y'all in the bushes, if you would like for me to say what's popping to you, you got to say something in the comments. Anyway, let's get into this. Now, this is from Jay Clayton on behalf of the government. And like I said, it was filed last night, honey. All right. So he says, despite this court's clear ruling that the defendant must be detained pending sentencing following his conviction on 2 felony counts, the defendant moves again for bail. Child, we starting off already. He's like, you doing this again? Like once again, how many times do you have to be? Like that's the tone that it gave me. And I said, that is the first sentence of everything that he's doing. Anyway, child, let's continue. As the court correctly found after written and oral submissions by the parties on July 2nd of 2025, the defendant's detention pending sentencing is mandatory. There is no exceptional circumstance justifying his release. And even if there were, the defendant cannot demonstrate by clear and convincing evidence that he is not a danger to the community. Further, following the court's unambiguous ruling, the defendant now seeks relief without even attempting to demonstrate a reason for reconsideration. Basically, baby, he's saying they out here asking for bail and they ain't giving us no justifiable reason for reconsideration of anything. You giving us more of the same? True. Now do y'all see why I said this is a clash of the titans right here? Anyway. All right. Further, following, oh, I already read that. Because the defendant's motion fails to demonstrate any of the required showings, he fails to carry his burden and the motion should be swiftly rejected. Baby, I told you they're coming in hot, okay? Now, number one, the defendant has presented no reason for the court to reconsider its detention ruling. The defendant asked the court to reconsider its July 2nd, 2025 ruling that the defendant must be detained pending trial, but fails to even address the proper standard for a motion for reconsideration, let alone meet it. The court properly denied the defendant's request for bail on July 2nd of 2025, and the defendant has failed to present any reason for the court to reconsider its ruling. The court should deny the defendant's motion on that basis alone, applicable law. Whereas here, the defendant's bail application pending appeal was previously denied, a renewed motion for bail is properly considered as a motion for reconsideration by the court. Okay? And then it says to see U.S. versus Veleceres. I don't know how to say that last name, okay? And that was a case that was tried in the Southern District of New York on April 20th of 2023, finding that since the court already denied the defendant's request at the sentencing proceeding for bail pending appeal, the defendant's instant bail motion may be properly viewed as a motion to reconsider, okay? Then he goes on to cite another case, United States versus Reese, which was tried in the Southern District of New York on October 12th of 2022, okay, where denying a motion to reconsider detention ruling pending appeal, where defendant failed to meet standards for motion for reconsideration. Now, baby, let me tell you something. Over the course of time, and I just said this on my IG, I stopped reading the whole document the way that I was reading the whole documents prior to the trial, because people were like, oh, we just want to get to the information. No, I'm back to reading my court docs and doing the things that made me Henny, okay, and made this, when it was Hennessy reviews, that girl Henny reviews, okay? So let's get back into it. Now, as you can see, he used two cases, just like the defense used some cases to back up what they were saying. The government is using cases that back up what they're saying, that basically in these two cases, what they have shown us is that the request for sentencing, after all of this, it has to be why it's a motion to reconsider was the first one, why he put that in there, right? The second one is showing a denial, okay, of the reconsideration. And then he goes on to another one that says 3, denying motion to reconsider detention ruling pending sentence, where defendant fails to meet the standard for motion of reconsideration. So now we go on, and the standard for granting the motion reconsideration is strict. So he's saying, yeah, this is not, hold on one second. So basically what he's saying is, look, even to reconsider it, this is a strict thing, that this is not some lackadaisical reconsideration or motion or whatever. This is something that the policies for it, they're not a 1, 2, 3 type of thing. I'm sorry, I'm trying to do two things at one time. Multitasking is a thing, but not really a thing. All right. So now he goes on to Schrader versus CSX Transportation Inc., and he cites, although the federal rules of criminal procedure do not provide for motions for reconsideration, local criminal rule 49.1 permits such motions under certain limited circumstances. Okay. Then he goes on to say, a motion for reconsideration of a court order determining a motion must be filed within 14 days after the court's determination of the original motion. The memorandum, no longer than 10 pages in length, setting forth concisely the matters or controlling decisions that counsel believes the court has overlooked, must accompany the motion. Now, we've already talked about time. And I've already told y'all that time was of the essence with certain things. So now he's saying that the bail motion, it had to, from what I'm reading and how I'm understanding it, the bail motion must have been filed within 14 days. Okay. Okay. Just so you know what we're talking about. Hold on. Go to that one. Now, prior to the adoption of local rule 49.1, courts in this district applied local civil rules for motions for reconsideration in criminal cases, and thus courts apply the same standard of review for motions seeking reconsideration under local criminal rule 49.1 and local civil rule 6.3 and the federal rules of procedure, United States versus Stewart. Baby, I'm telling you, he's not playing. Okay. Now, do y'all want to go and look up these rules? We gonna look up some of these rules when we get done, okay? So that we can understand. So that we can understand exactly what it is. Why? Hold on, I'm trying to send something. It's not letting me send. All right, you'll have to wait. All right. So, a motion for reconsideration will generally be denied unless the moving party can point to controlling decisions or data that the court overlooked matters. In other words, that might reasonably be expected to alter the conclusion reached by the court. To warrant reconsideration, the moving party bears the heavy burden of showing an intervening change of controlling law and availability of new evidence or the need to correct a clear error to prevent the manifestation of injustice. Now, when I read this part right here, I was trying to understand exactly what it was that Clayton was getting at here, because it sounds like not only is he addressing the bail, it sounds like he may also be addressing some of these other things that came out as far as the Rule 22 and 29 and the Rule 33. It sounds like he's combining some of those things in there, but basically what he's telling them is like, look, just like the judge said when we were in court, the judge was like, listen, before we even started all of this, the burden of proof was on the government on why we should not give bail. But now the burden of proof is on the defense. And the defense submitted what they had to submit. And the judge, even in his own words, said, this is not getting it, basically. You know what I'm saying? He was like, this is not addressing things. And the judge was very clear on why he was denying bail. And it was because of the propensity for violence, you guys. It has nothing to do with anything else except for the propensity of violence and the fact that Congress says that there's supposed to be detention that happens. All right. So that those are the things. All right. So now it says, unless otherwise noted, okay, these were in the notes. We're going to go back and we're going to read these notes. All right. B, discussion. The defendant has failed to meet the strict standard for reconsideration as an initial matter. The defendant's motion is untimely under Rule 49.1D. The motion was filed 27 days after the court's July 2nd, 2025 bail determination. The defendant fails to meet Rule 49.1D's 14-day deadline. So when coming in for this reconsideration for bail, here we are talking about the 14 days. Now, remember, I told you Rule 29 has 14 days. It's looking like the bail has 14 days. And I'm going to go out on a limb and say that everything has 14 days, which is 2 business weeks for them to be able to file anything like the Rule 29, like this bail. I'm wondering if he's going to hit them with a 14 days for this Rule 33, this acquittal that this new trial that they're going for. I'm curious because he hasn't really responded officially to the acquittal or the new trial motion that was put in yesterday. Okay, so I guess today Judge Arun Subramanian will get this response for the bail from the government and go over it. And at that time, he'll probably give the government another date on when they should have their response to that motion in. And I wouldn't be surprised if old Jay Clayton isn't sitting in there clickety clackety, clickety clackety, clackety, click, 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 click. Like what was that Bruce Almighty when he was sitting there? He's probably like that. Okay, he's probably sitting. Anyway, let me put some music on because I hate when it's quiet and I just feel like okay, that should be good enough. All right. So further, the defendant fails to point to any intervening changes of controlling law, new evidence, clear error, or need to prevent a manifest injustice as required. Indeed, the defense previously presented to the court its assessment of the defendant's risk of flight and dangerousness. The defendant's current motion raises no new issue that the courts overlooked in that regard. Similarly, during the bail hearing, the defendant put forth the argument that it argues here with respect to exceptional circumstances, namely the circumstances that the defendant's Mann Act conviction presents exceptional circumstances warranting his release from custody. The court heard defense counsel on that point and rejects its position. I'm sorry. I'm laughing because Henny Glasses in the chat, if you think Alexandra Shapiro is going to come back. Child, when I tell y'all this is basically what he hit him with is a heard it all before. I was at work. And I'm laughing only because I find it like it's funny to me. Listen, we gotta laugh. We have to laugh at this because this is it is what it is. I'm not gonna apologize for laughing. I'm not, because it's funny. It's funny to me. You know why it's funny to me? Because I said this. I said this is stuff that we have already heard that they're saying. They're not really saying anything new. It's the same thing is being said. It's repetitive. So now he's saying this is repetitive. They haven't presented anything new. Okay, it won't do it on the phone. All right, boom. All right, so finding that irrespective of any exceptional circumstances, the defendant could not establish by clear and convincing evidence that he was not a danger to the community. And remember, that's been the thing that has been a theme. And like I said, with the judge saying the propensity for violence, this is the thing that they need to be focused on. They need to be focused on that. How is he not going to be a threat? You're posing all of this stuff, but you proposed having security there. You're not really giving anything new. That's what Jay Clayton is saying. I'm sorry you feel like it's a waste of money that's being spent, but I'm quite sure there are people that don't feel that way. Okay, so in addition, as discussed below, the defense raised the conditions at the MDC, okay, with the court during the prior bail hearing, but stated the opposite of what they now claim, okay, which is the MDC, okay. Previous extraordinary circumstances, okay? See transcript 8158, 9 through 11. I want to thank the MDC. The MDC gave us good access to him. They made it work. And Your Honor helped us out a great deal by giving us access to him. The defense cannot now claim that there was an intervening change in the conditions at the MDC to justify the court's reconsideration. Doing so would relitigate old issues, or otherwise take a second bite at the apple, which is not the province of a motion for reconsideration. Accordingly, since the defense has failed to carry its burden showing controlling decisions or matters overlooked by the court should deny the defense's motion for reconsideration from the court on July 2nd's order. So basically what they did is they took what Mark Agnifilo said in court when he thanked the judge for helping them and saying, oh, I thank the MDC because they gave us access to him. They worked with us, yada, 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 yada. Now you're coming back and saying that the conditions are horrible. So basically, just like the judge used their words against them, Jay Clayton is using their words against them now, because you can't talk both ways. You can't say that they were helpful and this and that, then come back and talk about something else. But I think what the defense is talking about here is they're talking about the fact of the conditions that he's under as being an inmate there, and not so much that part. But again, here we go. This is the government side of it. The defendant has failed to show any exceptional reasons, even setting aside the defendant's failure to meet or even address the proper standard for a motion for reconsideration. The defendant's motion still fails. As this court previously found, because the defendant was convicted of felonies under Chapter 117, his detention is mandatory pursuant the Bail Reform Act. So this is what I was talking about with you guys earlier when I was saying to y'all that the judge, all of this, they said that it was mandatory that he had to be detained. And so now they're citing that under Chapter 117. So we're going to look some of these things up so that we can make ourselves knowledgeable of what these things are once I'm done reading this document. Okay. So we're going to look up that 49.1 and a point D and all. We're going to look up all of that stuff. I'm going to come back over here and I'm going to pull all of that up. We're going to Google. We're going to use Google. Okay. So if anybody has a problem with us using Google University, then I feel sorry for you. That's a you problem. We gonna learn over here today. That's what we do. We learn over here as well as being. Are you not entertained? Anyway. So it goes on to say, as the court previously found, because the defendant was convicted of felonies under 117, his detention is mandatory pursuant to bail reform. I read that again for those who didn't catch it. And once again, the defendant has not met the requirements of the so-called safety valve, which requires defendants to prove by clear and convincing evidence that they are not a flight risk or danger and that exceptional reasons exist, making detention appropriate. Okay, the defendant's attempt to avoid the mandatory detention provisions by claiming that his prosecution under the Mann Act is somehow unique is both incorrect and irrelevant to his motion for bail. Moreover, the defendant's arguments that the defendant faces exceptional circumstances at the MDC is belied. Okay, that word by the factual record, including multiple statements made by counsel for the defendant. There are no exceptional circumstances here, and the defendant's motion can be denied on this basis as well. Okay. Then he goes on to say that there's nothing exceptional about the defendant's Mann Act conviction. Now, I have to say, I'm going to have to read this, because I say the only thing that makes it really exceptional is the fact that we don't know of anybody who caught a Mann Act like this, right? So let's see what he says. The defendant spills much ink. The shade of it all. Are y'all picking up the shade? Because the defense be having some shade in their stuff too. That's why if they decide to respond to any of this or they put another motion, we're going to read the whole damn thing. Okay. I'm not skipping over nothing. So if it's 57 pages, we going to read 57 pages. Okay. I'm back on my bullshit. Anyway. The defendant spills much ink explaining why the underlying facts of his conviction make his continued incarceration exceptional. That's professional shade right there. Anyway, however, the defendant's arguments are baseless, misleading, and run counter to the clear intent expressed by Congress. First, the court should not entertain the defendant's request to override the clear intent of Congress by putting aside the mandatory detention provisions in subsection 3143A2 in favor of examining the facts underlining his conviction. The defendant points to no authority for the novel theory, nor could he because Congress could not have been clearer. Those defendants found guilty of any felony under Chapter 17 of the United States Code shall be detained. Did y'all hear that? Okay, let me highlight that. It says, Congress could not have been clearer. Those defendants found guilty of any felony under Chapter 17 of the United States Code shall be detained. That right there. So this is why when the judge was making his ruling, he was saying that it was mandatory, that he had to stay detained. All right. It says Congress did not say that mandatory detention applies only to some felonies. The shade of it all, honey. Oh my goodness. Okay. Congress did not say that the mandatory detention applies only to some felonies under Chapter 17, depending on the facts underlying the conviction. Congress said that mandatory detention applies to any felony under Chapter 17. And the reason I'm doing this is because they have that in there. So I'm just giving y'all the air quotes as we read along. Okay. Okay. Under Chapter 17. Okay. Now, the defendant's Mann Act convictions are such felonies. Okay, encouraging the court to consider the facts underlining the defendant's convictions as exceptional reasons under subsection 3145 defies Congress's clear intent to make detention mandatory with respect to certain categories of felony convictions. District courts certainly have broad discretion to consider what constitutes exceptional reasons, but accepting the defendant's invitation would eviscerate the congressional intention underlining the mandatory detention provision contemplated by the Bail Reform Act. Okay, instead of creating a carve out for Mann Act convictions that follow a particular fact pattern, indirect conviction with indirect conflict with the Bail Reform Act, the court should consider the nature of the offense where Congress has instructed it to, in asserting the defendant's risk of flight and danger to the community. Okay? Directing judicial, okay, so U.S. Code 18 subsection 3142G1 is directing judicial officers to consider the nature and circumstances of the offense charged in determining whether there are conditions of release that will assure appearance and the safety of the community. All right, so that is what is in that subsection 3142. Paragraph G or section G, paragraph 1 within that section. So yeah, that's how you read that. So second, there is nothing unusual about the defendant being detained after being convicted only on Mann Act. See United States versus Blake. Okay, defendant charged with sex trafficking and Mann Act violations remained detained after pleading guilty to the Mann Act violation. United States versus Kaiser. The defendant charged with sex trafficking and Mann Act violations remained detained after pleading guilty to Mann Act violations. Simply put, a criminal conviction, even one that the defendant egregiously suggests is novel in its application of the statute of conviction, is a far cry from the types of exceptional reasons sufficient to justify bail pending sentencing where mandatory remains applied. We feel the reasons proffered by the defendant though unfortunate, are not exceptional. So basically, there's one thing that I noticed in those two cases that they cited. Those people pled guilty. Diddy did not. So you see how I said, remember when I was telling y'all that the defense wasn't going to find something that aligned completely with Diddy, just like they used examples of a college student who was working full time and it was his first offense, and how they gave him bail or released him of his own recognizances. And then the next guy, Chavez, how he was 74 years old, and they talked about the lockdowns and the medical treatment that was he was not getting, but he was 74 years old. So, you know what I'm saying? In this instance, they're using that. But those people in those cases pled guilty. So again, you're seeing how both sides are not finding something that is identical to Diddy's case. Neither one of them are going to find that, because even though they're saying this isn't exceptional, I'm sorry, you guys, I have to keep it real. They're saying it's not exceptional, but it is unique. If you don't want to say it's an exceptional thing, then it is definitely a unique situation where they really have to consider what they're going to do, because now this is going to be a precedent. And I told y'all that before. All right. The defendant cited two cases that he claims involved similarly situated defendants, and in which the defendants were released on bond conditions following Mann Act convictions. However, even in cursory review of those cases reveals that other than the statutes of conviction, these defendants are not even the slightest bit similarly situated to the defendant. The defendant first points to the convictions of the defendant John Trowbridge, Michael Stebeck, and Ronald Tills in the Western District of New York, and claims that because those three individuals were released on bonds following their guilty pleas, he should be released on bond. But these defendants were all far less culpable than the defendant. And in fact, the government never sought their detention pre-sentencing, nor did the court appear to consider mandatory remand. So what he's saying is, in those three cases, it's nothing like Diddy's, okay? That the Western District wasn't even trying to seek detention. All right. But in this case, in the Eastern District, they were seeking detention of Diddy prior to the trial. So that's where it differs. And that's what they're pointing out. Unlike the defendant, who transported men and women repeatedly for purposes of engaging in prostitution over the course of more than a decade, Stebeck was convicted of conspiring to transport a woman across state lines for purposes of engaging in commercial sex work on a single occasion. Similarly, Trowbridge admitted to transporting women across state lines on 2 occasions, and Till, who was sentenced to 18 months imprisonment, admitted to transporting women across state lines on 6 occasions within a 2-year period. So what they have done is they have gone into these very cases that the defense is using to back up their motions and said, look, it's not even... They didn't even bring up the ones that I mentioned. See, this is why I like reading, because you learn stuff. So basically what they're saying is, in those cases right there, they didn't do all of this transporting for over a decade. One did 1 instance, another one did 2, and another one did 6 instances of it. But none of them did a decades-long transporting or 2 decades-long transportation, a Mann Act. They wasn't doing it for that long. Okay, so that's where their argument is coming in at. Moreover, none of the Trowbridge defendants were alleged to have physically assaulted anyone in connection with the conduct, and Stebeck's transported the victim, but did not have any sexual contact with her. So in this instance, what he's saying is Trowbridge, there was no physical violence that was involved. So now we're getting into the physical violence that was shown to us at the Intercontinental, okay? And I know people are like, how does that even equate? And I had to think about this too, on how it would even equate. So basically how they're equating the Intercontinental into this transportation is because there was a sex worker that was flown in and that was in the room. They had just finished doing a freak off, okay? And Cassie was leaving. And so what the government has been saying is that when Diddy put hands, feet, and knee bows on Cassie in that lobby, and drug her, tried to drag her back to the room, that he was trying to drag her back into a freak off situation, or at least a freak off setting. Okay. Regardless to what, Cassie testified that that was her phone, those were her belongings. And even if you watch the whole video, towards the end of the video, when Diddy is by himself, he walked down the hallway and he comes back. This is after security left. This is after Cassie left. You see him walking down the hallway and he has a regular phone in his hand. So that bright light up phone was Cassie's phone. Those were Cassie's bags. There were no substances. There was no money in those bags. There was nothing of his that was on her at the elevators. So they're using that because there was a movement that happened, a transportation that happened. So they're linking that to that, right? Then you have the situation with Cassie, with Jane. And there was another. So this is where he's saying that there was no violence that was involved in Trowbridge. And in Stebic, he wasn't having relations. He wasn't having sex with the people. Diddy was having sex with Cassie and he was having sex with Jane. So they're pointing out the differences in the case. I would like to see the defenses clap back to this. Okay? Because if they're picking apart their stuff, you know the defense is going to pick apart theirs. So it's about to get spicy, y'all. Get out your feelings and get into some of this hitty. This is hot hitty that they are spilling. Or tea for those who like tea. All right? Moreover, none of the Trowbridge defendants were alleged. Okay, we already read that. Further, both Trowbridge and Stebic immediately admitted to their conduct, and both provided substantial assistance to the government, resulting in the government's moving at sentence for a downward departure. So because they pled guilty, because they were, cooperating with giving the government their information, like basically self-snitching, admitting to things, there was a downward departure that happened on behalf of the government because they pled guilty. So again, when they go into those cases, let's look at what they're saying is different. They're saying that none of them operated in a decades-long Mann Act, okay, or 2 decades-long Mann Act. They're also saying that none of these people that they have used as their defense, none of these people have been physically violent with the people that they were transporting. They're also saying that there was no sex that was had between the person who was transporting and the person that was being transported. So there's none of that. So they're saying that because of that, that's why these cases are different. All right. Okay. I have to use my other glasses and I don't like them because they're stronger than my other glasses. But I told y'all I broke the arm on my glasses because, I fell asleep with my glasses on and broke them. These are stronger than those and I hate them. All right, so the defendant also points to the conviction of Mario Collins, who was ultimately sentenced to 24 months imprisonment after he was convicted of a Mann Act violation for transporting a victim on a single occasion. Collins was released after a mistrial was declared on the charges, against him, including sex trafficking and Mann Act offenses, and remained on bail after his subsequent conviction of the Mann Act. All right, the U.S. versus Collins. The defendant argues that he, like Collins, should be released, but this case does not bear the weight that the defendant attempts to place on it. At the time that Collins was initially released after mistrial, Collins was not subject to mandatory remand because, unlike the defendant, he had not been convicted of any offenses. Moreover, while Collins remained on bail after his conviction, it is entirely unclear whether the court even considered the mandatory remand provision. That the conclusions that can be drawn from the court's bail decision in that case are limited at best. So, what we're talking about here is mandatory remand, which is what he's talking about that Congress brought down on anybody who was convicted under a Chapter 117 charge. Now, that's crazy work. Let's continue. Third, even if the court were to consider, and I'm going to get to y'all comments, I promise y'all, I see the comments going up. But I'm going to get to y'all comments. But y'all know while I'm reading, I don't really do the comments because I don't want to lose my place and get distracted. I want to give it to y'all, and then I will scroll back up and I will get into y'all comments, okay? Third, even if the court were to consider the facts underlining the convictions in considering exceptional circumstances, the nature of the defendant's crimes reflect aggravating, not mitigating factors, and therefore support the defendant's detention, not his release. The court should reject the defendant's minimized version of his own conduct when he describes himself as a mere John. Far from being an ordinary or casual customer of commercial sex, the defendant transported individuals for the purposes of prostitution on hundreds of occasions over the course of decades. Plied Cassie and Jane, as well as male commercial sex workers, with drugs to ensure their continued participation in days-long freak-offs, used violence against both Miss Ventura and Jane in connection with freak-offs, and employed a small army of personal staff to ensure that his every need was met during freak-offs. The defendant's actions surely distinguish him from an ordinary John. Child, listen. A read. Did he read? Y'all throw some books down in the chat if he read. Okay? He said, he trying to downplay his role and all of this and say he's just a John. He said, you ain't just no John, sir. Okay? Let me explain to you how you not a John. I see Miss Jalen down there said, child. Baby, do you hear me? Hold on. When I tell you, and look, I'm looking forward to what they gonna say. What is us finna do, Jesus? What is us gonna do? I want to read the comments. I want to read the comments so bad, but I can't. And I see the books going up because, baby, wait a minute. She said, a reading rainbow. I can't go anywhere. Take a look. It's in a book, a reading rainbow. Listen, y'all, listen. See, that's why I can't get in them comments with y'all, because y'all gonna distract me every time. Finally, okay, we got to a finally, y'all. After all of this, he done finally said finally. Finally, the court should reject the defendant's pages-long recitation. He said, look, you gave us pages of the same thing. You just repeating yourself over and over. Oh, okay. Finally, the court should reject the defendant's pages-long recitation of historic Justice Department policy as both irrelevant and misleading. In the past, the department had a policy specifically related to enforcement of the Mann Act, which focused on prosecuting the Mann Act in the context of commercial cases. But the department no longer has specific policy related to the Mann Act. In fact, the department's current guidance includes a policy title, Prosecution of Customers Involved in Federal Sex Trafficking Offenses, in place since December of 2020, which prioritizes reducing demand for sex trafficking by prosecuting those who engage in commercial sex with victims of sex trafficking, including buyers of commercial sex. Wait a minute. Hold on. You mean to tell me that in 2020 they passed the law? Because I Could have swore they updated it in 2024, something like that. I don't know, but child, you mean to tell me Congress said we finna crack down? I'm sorry, y'all. I can't use those glasses. They are too strong. Side note. When you go get your eyes examined, pay attention to what them optometrists be doing, because they give you glasses that are stronger and they make things blurred and they give you headaches because the prescription is too strong and they're actually making your eyes worse. These are my glasses that I had prior to the gold ones, and I see just fine out of them. The only reason why I wear the gold ones is at night so I can see when I'm driving, because sometimes my vision get blurry and I can't see. I can see colors, but I can't see signs. Anyway, let's get back to what we're talking about. So basically, there is a provision in the Mann Act, which I kept to myself because I was thinking to myself, I said, myself said, girl, what do you want now? And I said, I'm sorry to bother you, but I got a question. So with this Mann Act stuff that's going on, why they don't charge the people who are purchasing? And myself said, girl, you going down a rabbit hole that that's not in our pay grade, baby. So I left it alone. Look, myself be talking to me. Okay. Myself be talking to me. I see the super chats going up. I got y'all in a minute. Let me finish this up. Whew. Now it says, see Justice Manual subsection 83.400. Now, let's go down here to this little note. It says, also see October 17th, 2019 statement by Beth A. Williams, Assistant Attorney General for the Office of Legal Policy at the 2019 Just Conference, announcing DOJ initiates focusing on sex trafficking demand reduction and emphasizing the importance of targeting demand for commercial sex. Well, I guess there goes that argument out the window. All right. So in other words, it is squarely within the priorities of the modern day Justice Department to charge the conduct described above under a variety of federal statutes, including the Mann Act, which is exactly what the government did in this case. The defendant's suggestion otherwise, relying on deficient policies is inaccurate and misleading. Okay, then they go into the defendant's detention at the MDC is not exceptional. Child. The defendant claims that his conditions of confinement at the MDC are exceptional circumstances. For the reasons described below, they are not. I swear to God. Who is Jay Clayton? Because on paper, we know what Jay Clayton looked like, okay? Because Jay Clayton is the dude that is on the thumbnail, okay? But who is this man? Because we know what he looked like, but that ain't what he read like. Oh, people aren't really liking me today, you guys. I think I should go in a corner and cry. Because I keep watching these numbers going up and down and all around, and mofos is really like trying it. That's okay, because I know how to outsmart a motherfucker. Okay? In making this argument, the defendant relies primarily on Judge Furman's opinion in United States versus Chavez. In that opinion, which was published on January 4th of last year, over 8 months before Combs stepped foot in the MDC, Judge Furman found that the MDC's conditions at the time, in conjunction with the defendant's old age, he didn't have to do Chavez like that. He didn't have to do him like that and call out his old age. Why he do that, Jesus? That's not cool. The MDC's conditions at the time, in conjunction with the defendant's old age and serious medical conditions, constituted exceptional circumstances under subsection 3145C. In doing so, Judge Furman described the conditions at the MDC at the time, which included extensive lockdowns, inadequate medical care, and problematic physical conditions. Problems attributed in large part to the MDC staffing shortage. The defendant claims without evidence that these conditions have not abated. have not abated. During his detention at the MDC, he is correct. During the defendant's stay at MDC, the facility has made enormous strides in increasing and stabilizing their staffing levels, improving medical service, and improving physical conditions. For example, we got examples, y'all. He said, let me break this down to the third power and the fourth for you. So he says staffing at MDC has increased dramatically, and correctional service departments at the MDC is staffed 94.2% compared to 55% in January of 2024 when Chavez was published. Medical staffing has also been increased, with the health department currently being staffed at 84.6 compared to 69% in January of 2024. The staffing has decreased. The lockdowns described in Chavez. In 2025, the MDC had not locked down or modified its operations in any housing unit as a result of a staffing shortage. So they said, we ain't locked down because we ain't got the staff. We locked down because they ain't here cutting up, figuratively and literally. Okay? Medical care has also improved. In addition to increasing medical staff, the MDC increased its use of telehealth services for quicker and more efficient medical checks for inmates. The MDC has undergone facility repairs and improvements, including in the past few months. They have included repairs to emergency call buttons, upgraded the security cameras, and improvements to the elevators. Hold on one second, because I'm triggered. I'm triggered because they saying they upgraded their security cameras. Well, isn't that what they said in the Epstein? They said that they upgraded the security cameras in that too. But we see how that turned out, because they upgraded the system, but the system wasn't working properly. So did y'all upgrade it? Is it running nicely and smoothly? Or are we having breakdowns like we did at the MCC? And the MCC ultimately ended up getting shut down. I just have a question. That was my question. Okay. Let's continue. It says that, we read that already. Given these improvements, Chavez no longer provides an accurate picture of the conditions at the MDC or a base to find extraordinary conditions under subsection 34.5C. Indeed, Judge Furman himself observed more than 2 months ago that conditions at MDC are a lot better than when I wrote my opinion in United States versus Chavez, including with regards to staffing levels, medical services, and incidents of violence described in more detail below. In addition to Chavez, the defendant also relies on United States versus Colucci, which is in the Eastern District of New York. So we got the Southern, the Western, and the Eastern District all coming up in here. All right. We need the Northern District. Okay. All right. In addition, in claiming there is unchecked violence at the MDC, he says, which places his safety consistently at risk. But this too does not serve as a valid basis for finding of exceptional circumstances. Like Chavez, the court in Colucci described violence that occurred over a year ago. Although there's no instances of armed violence in the summer of 2024, those incidents have declined. And inmate contraband, though still a problem, is being addressed by the facility. Among other things, the MDC has dramatically increased staffing, as described above, and now houses more than 300 fewer inmates and detainees than in January of 2024. The defendant perversely suggests that sweeping the jail for contraband and avoiding outside law enforcement agencies is doing somehow an admission to serious violence, mayhem, and chaos is occurring within the MDC. I don't have any commentary on that part, because what I can tell you is I'm not buying that part, because there's still things that go on inside of correctional facilities and prisons that don't get talked about to the outside world. But we're going to let them continue to go off, sir. I was going to say sis, but I'm going to respect them and say, go off, sir. So, and proves that the MDC is mismanaged and unsafe. Quite the opposite. These steps were taken to improve some of Hold on. We just got a hot Henny update. Oh, baby, this is going to be hot. This is about to be hot like fire. Let me hurry up and get through this because we got 3 more pages to go. And then I have a surprise for y'all. I have a surprise for y'all. So get ready. Get ready. All right. So quite the opposite. These steps were taken to improve. These steps were taken to improve some of the very conditions about which the defendant complains, and they have been working. Indeed, MDC is unaware of any violent incidents in the defendant's housing unit since his arrival in September of 2024. It is also worth noting that the defendant's bail motion is devoid of any claims that the defendant himself was impacted in any way by the conditions he alleges. The motion does not make any specific allegations regarding the defendant's own medical care, exposure to violence, or experience with lockdowns. In fact, the motion is the first the government has heard of any risk to the defendant's safety, or for that matter, any issue with the defendant's treatment at the MDC, aside from his requests during trial for additional time with his lawyers. To the contrary, defense counsel has repeatedly throughout the course of this case praised the MDC for its treatment of the defendant. So they go on to October 10th, 2024, transcript at 27. The MDC has been very responsive to us. Trial transcript 1729. The MDC has been very accommodating to us in many ways. Trial transcript 8158. I want to thank the MDC. The MDC gave us good access to him. By failing to raise any issue related to the defendant's experience with lockdowns, medical care, his experience with the physical facility, or his safety to the government's attention, defense counsel, we did not hesitate to repeatedly raise issues of access to their client during trial. Has deprived the government as well as the MDC staff and the court of any opportunity to investigate and remedy, basically that's what that means, these allegations. They should not now form the basis of a finding of exceptional circumstances. So basically what they're saying is the whole time we was in trial, you ain't have no issues with none of them. You wasn't saying nothing. You wasn't doing nothing. You wasn't talking about nothing being a danger or a threat. His safety at risk and all of that. Now, after singing their praises to allowing access and all of that, now there's issues when you could have been brought this up, but you didn't bring this up until now. Child, let's get into it. Given the vast improvements at the MDC, there can be no findings of exceptional circumstances, particularly here, unlike in Chavez, where the defendant alleged no compelling personal circumstances, such as significant health issues or old age. In other words, he don't pose none of the same things as Chavez. And I said that to y'all. I said Chavez was 74 years old with health issues and all types of stuff. So that was not. So see, you see your girl. Give it up. Your girl I be saying it. I be calling it, but they don't like me. So it is what it is. They don't be feeling me. Anyway. So let's go on all of those decisions. In addition, the defendant has not alleged anything near the individual circumstances that were relevant in Chavez. Okay. I find that the conditions, in Ramiro, United States versus Ramiro. This is from January 18th, 2024. United States versus Ramiro in the Southern District of New York. I find that current conditions at the MDC standing alone do not constitute such exceptional circumstances that I desire to avoid contributing to exacerbation of these conditions with respect to one defendant. Again, absent any particular personal issue as to that defendant is not a consideration that constitutes exceptional circumstance within the means of Section 3145C. So now he done pulled up a case that resembles all of that. Okay. Where we at? We on page 9. The defendant poses a danger to others. Let's hurry up and get through this because like I said, I got some hot Henny for y'all. I'm going to have to change my thumbnail too. Let me see. Henny Legal, I don't have what you said. I don't have what you said. Even supposing extraordinary, okay, defendant poses danger to others. Even supposing that extraordinary circumstances could be demonstrated, the defendant fails to establish by clear and convincing evidence that he does not pose a danger to the community. As the court found less than 1 month ago, it is impossible for the defendant, having repeatedly conceded his propensity for violence at trial, to demonstrate by clear and convincing evidence that he poses no danger to any other person or the community. Okay. And then he goes on to the trial transcript where it says nothing that defense conceded, noting that the defense conceded the defendant's violence in his personal relationships. Then trial transcript again, noting that the defense full-throatedly in its closing arguments, told the jury that there was violence there, and domestic violence is violence. The court properly concluded that this type of violence, which happens behind closed doors in personal relationships sparked by unpredictable bouts of anger, is impossible to police with conditions. The defendant presents nothing to disturb the court's findings, nor can he. The trial record is replete with evidence of the defendant's acts of violence towards others. The defendant's decades-long relationship with Miss Ventura was refined by his repeated acts of violence and abuse. The defendant's temper and violence were unpredictable. The defendant frequently punched, kicked, and dragged Miss Ventura, leaving her bruised and cut with black eyes and busted lips. This abuse often occurred during freak-offs, including the defendant's assault of Miss Ventura at the Intercontinental Hotel, which was captured on video surveillance. Now, there was one instance, but Miss Ventura and other witnesses testified to numerous acts of brutality by the defendant against her. In addition, and they list all the transcripts, okay, and the pages. Transcript 276, page 77. Transcript 282, page 83. Transcript 576, page 77. Transcript 688, page 90. Transcript 763, page 64. And it goes on and on. In addition, the defendant was also violent towards several of Miss Ventura's friends who witnessed his mistreatment of Miss Ventura, including Mia, Deontay Nash, Brianna Bonabangalo, and Kerry Morgan. The defendant was also violent towards Virginia Gina Hunn, with whom the defendant was in a relationship at the same time with Miss Ventura. Okay, so it's not a document right now, but we do know that something is there. Okay. Now, I'm going to tell you right now, people finna come and they finna be like, oh, they using Mia. Mia's a liar, and Deontay's a liar, and Brianna Bongalon is a liar, and Kerry Morgan is a liar. Just know that when you go into other videos, that's what you're going to hear, that everybody was a liar. They're all liars. That's what you're going to hear. Listen, don't shoot the messenger. I'm just warning you. That's what you're going to hear. That's what you're going to hear. Okay. More recently, the defendant brutally attacked Jane in June of 2024, also in the context of a freak-off. As Jane testified at trial, after she initiated a physical confrontation with the defendant, she repeatedly locked herself in rooms in her home to protect herself from the defendant. Trial transcript 5,182, page 85. The defendant kicked down doors. The defendant also kicked Jane's legs out from under her, picked her up, in a chokehold, punched her in the face twice, punched her and kicked her repeatedly when she was on the ground, curled up in a ball, and smacked her in the face 3 times while she was showering, resulting in Jane losing her balance and falling to the ground. Trial transcript 5108, page through 5,202. Jane was left with a black eye and bruising and welts on her head. Trial transcript 5,229 through 33. GXE, this is the government exhibits. The defendant, who is significantly larger in size than Jane, had no visible injuries from the altercation. Under these circumstances, the defendant claims that his violence against Jane was somehow provoked is disgraceful. Moreover, the fact that the defendant committed this vicious attack more than 3 months ago to his arrest, more than just 3 months prior to his arrest, and while he was unambiguously aware that he was under federal investigation, highlights, the court concluded, a disgrace for the rule of law and the propensity for violence. The defendant contends that he does not pose a danger because the trial record does not reflect acts of violence by the defendant between 2018, when he ended his relationship with Miss Ventura, and 2004, when he viciously attacked Jane. As an initial matter, the defendant's violent attack of Jane and his years-long proclivity towards violence against Miss Ventura and others is more than sufficient to establish dangerousness. But the defendant's suggestion that he went several years without inflicting violence on another person simply is not true. The defendant did engage in several acts of violence between 2018 and 2024, and they blacked this part out. They redacted this from us, and I'm going to tell you why they redacted this from us, because they are probably talking about Gina in that part right there. And I told y'all yesterday, even though we had watched Tasha K and we watched what Gina had said to Tasha K about the violence that he inflicted on her, allegedly, because we have to say allegedly, even though it's going across the bottom of the screen on a ticker tape. Gina was supposed to be somebody who testified in this case, but did not testify in this case. So we know, even though it's not in the court record, we know that there was another relationship there. And like it was recognized in this right here, that relationship covered the gap between 2018 and 2004. Gina was there when he was with Cassie, and Gina was there when he was with Jane. So when Gina dropped out, that gave that missing piece. I be on it. I be giving y'all the real, but don't nobody want to hear it, okay? All right. Although this violence was not presented at trial, I told you they was talking about Gina. Although this violence was not presented at trial, the court is free to consider it in assessing the defendant's dangerousness. So they can go back, even though, child, wait a minute. So they can go back when the judge goes to make his decision according to this, what Jay Clayton just said. Even though she didn't testify in court, there's still a record of it, which means that the judge can use that record still in making his decision. Sherm. Hey, Sherm. Who is this? I don't know you. Sherm, what you talking about? Who you talking to? Jumping off the top rope. You know what? I don't know what y'all talking about in the comments, but I'm going to keep over here where I've been at. So I'm going to read that one more again. Damn, I got to be careful with my glasses, y'all, before they fall apart on my face. Although this evidence, okay, because see, now remember, they said it's simply not true. The defendant did engage in several acts of violence between 2018 and 2004. Although this evidence was not presented at trial, the court is free to consider it in assessing the defendant's dangerousness. See United States versus Lafonte. Recognizing that proffers are permissible both in a bail determination and bail revocation extensions. The defendant's extensive history of violence and his continued attempt to minimize his recent violent conduct demonstrates his dangerousness and that he is not amenable to supervision. The defendant utterly fails to establish by clear and convincing evidence as required that he does not pose a danger to the community. So yeah, he's using Gina, because remember, Gina had to go testify before the grand jury. Gina had to go meet with the government and be interviewed by them, and all of that stuff is transcript, which means that the judge can go and pull those transcripts and read that stuff that we're not privy to right now. I wish we could get the grand jury transcripts, child. When the grand jury transcripts, if they ever become available, I don't know if they do, but if we ever get our hands on that, baby, I will be right here by your side reading them. Oh, excuse me. Now, it says the defendant is a flight risk. Child, my coffee getting cold. The defendant also fails to establish a clear and convincing evidence that he is not a flight risk. The defendant faces significant penalties for his crimes of conviction, as raised in the government's July 2nd, 2025 submission. The government's initial view was that the defendant's guideline range was 51 to 63 months. The government is continuing to assess the sentencing guidelines and expects that the appropriate guideline range will be substantially higher. Did y'all hear that? Bye. What you not about to do is come in here and harass people. See you later. Sherman, don't you leave and go nowhere. She in the shadow realm. What, you want me to read it again? Nino said, sorry, Henny, I missed that. The chat threw me off. Yeah, that's why I got her up out of here. I hope Sherman is still here and she ain't chase him out. Okay, so boom. Let me read this to you again. As raised in the As raised in the government's July 2nd, 2025 submission, the government's initial view was that the defendant's guideline range was 51 to 73 months. The government is continuing to assess sentencing guidelines and expects that the appropriate guideline range will be substantially higher. Do y'all remember when I first told y'all we got to go back to that Marine Comey video? Because in that video, I said to y'all that we was going to see how Trump really feel about Diddy, because this is a Trump appointee. Child, we'll get into that conversation after we done reading, because we got this and one more page, well, the last page, and that's it. And we're going to start chopping it up, and I'm going to talk to y'all in the comments, all right? The possibility of a substantial sentence, such as in this case, is a significant factor in assessing the risk of flight. See United States versus Scully, United States versus Fishman. Moreover, the defendant's endless financial means, coupled with the demonstrated ability to conceal his crimes, his past efforts to bribe security officers, trial transcript 186, 3,905 through 54, as well as his general disregard for the rule of law above, serve collectively to create a substantial risk of flight. Okay? Accordingly, the defendant has also failed to demonstrate by clear and convincing evidence that he does not pose a flight risk. In conclusion, for foregoing reasons, the defendant's motion should be denied. J. Clayton, United States Attorney. Co-signed by Meredith Foster, Emily Johnson, Christy Slavic, Meredith Reddick Schmeiser, and Mitzi Steiner. Child, what did we just read? let me just tell y'all, I am on doc watch. I don't know when this doc is going to come out because, baby, there we go. Here it is. All right, let me open this up. Let me get back over here to y'all because, baby, I listen. Okay, let's remove that from the stage. Let me get this up here for y'all because I'm gulping hard. Boom. Now, we don't have the exact here is a text response, okay? It says full docket text for document 486. It says letter response to motion by USA as to Sean Combs addressed to Judge Arun Subramanian by Christy Slavic, dated July 31st, 2025. Motion letter addressed by Judge Arun Subramanian from Mark Agnifilo. This is what's in there. This is what's in there. So that letter actually came from Slavic. So it looks like Slavic may be the person who's taking lead. But child, did y'all hear that? I think I need to put that back up on the damn screen because that part right there. So what have we learned? We have learned that Jay Clayton is going to take this to the max from what he's saying in his letters. He's saying he about to take this to the max, baby. And when we were watching about Marine Comey being fired, I said to y'all that Jay Clayton was being appointed to fill in for Marine. And Henny Legal and I were talking about this. And, we came to the conclusion that if Trump, we're going to see how he feels really about Diddy when Jay Clayton get up in there. If he has a hand in this. And I don't know. I'm not going to hold y'all. And this may shock some of y'all, but my heart dropped to my butt when I read that. And I read that last night and I read it again today and it dropped to my butt again. No, Black Gold, he took over for Marine Comey. He stepped in Marine Comey's place on this case. That's what I'm talking about, this case. He stepped in for Comey on this case. So what had happened with this case, Damian Williams was there, and then Marine Comey took his place. And now Marine Comey is gone, and Jay Clayton is now in her place in the lineup of the U.S. attorneys. But he wasn't on the case, is what I'm saying to you. That's all I'm saying. I'm not disputing what you're saying, but what I'm saying is he was not a part of the team that was prosecuting Diddy. He's now a part of the team. He wasn't in the courtroom. He wasn't signing on their stuff as somebody who was in the courtroom. So he's now being vocal and signing off on letters. Now let me scroll back up and let me see what some of y'all are saying. Oh, wait, let me go into this. Thank you, Jaylyn, for the super sticker. And thank you for the super chat. She said, reading Rainbow for String. I was about to sing. She said, reading Rainbow for Swingers. This is voyeurism, baby. She also said, thank you for the super chat. She said, starting a petition for a Henny phone line. I don't need a phone line, baby, because no, if people start calling my phone, I will never get through the day. All right. Welcome, Lucky Gambino and Miss Jaylyn to the members section. Yay. Let me tell y'all something. When I get into members, we do spooky stuff. We do Wicked Wednesdays where we watch spooky things and things that are spiritual in nature. Things that, our spiritual in nature, we do that, but then I'm also getting into some other things as well. So welcome to the members. You will see that things are different on the other side. We talk about everything over there. We get on there and just talk sometimes, okay? Hold on one second. Okay. As I'm talking to y'all, there's things going on behind the scenes, all right? You're right. Yes, there's a lot of things that are happening within the correctional facilities themselves, you guys. So when they say things like, oh, we've improved and we've hired and we've done and we this and we that and we, yeah. I don't believe you. I just had I have loved ones that are in different places and spaces, and I had a loved one who came home not too long ago from the feds, and I told y'all before he was in Hazleton. So while these people be out here trying to discredit me and all of that with their little subs about how they've been in the feds or they've done the feds and all that other stuff, yeah, I have loved ones who have been in the feds. Next time they say that, ask them about Hazleton, because I did my research when my loved one told me to. And even Cardi B has spoken out about Hazleton, and that's where they were, and they were in lockdown all the time. Okay, all the time. And in doing my research, I found that they are one of the worst BOPs to be in. So yeah. Anyway, the conditions, I haven't been in there. I know they were just there last year. I could ask them what the conditions were from an insider's perspective last year and come back and let y'all know. But that's why I said what I said yesterday about them trying to use the MDC, him being there, as exceptional circumstances. If that's the case, everybody that's in Brooklyn's MDC should have exceptional circumstances, because it's horrible. It's horrible. Okay. And you really got to look at all of this. You really have to look at all of this, because MCC was closed down. And that should tell you a lot. Okay. Somebody was unalived in there. And yes, I believe that Epstein was unalived. Now let's get back into all of this Trump stuff that's going on with this case and this Jay Clayton person, right? So Jay Clayton, like I said, was appointed by Trump, okay, into the Southern District of New York. Now, I find it, the reason I say that he may be making an example out of Diddy is because right now MAGA is pissed off with Trump, okay? Because he made a promise that he was going to release all of these Epstein files, and that was his campaign run, right? And so now he gets into office and he's not there. Why? Because you're in those records too, sir? Or did you shred those when you took those classified documents to Mar-a-Lago? Also, just like they're saying that there was an affiliation with Epstein and Trump, because there was also an affiliation between Trump and Diddy at one point in time throughout the years, because there's different stages of Donald aging where he met Diddy or was photographed with Diddy, and even photographed with Diddy and his wife Melania, or Malana, however you say her name. I don't keep up with it. All I know is she's not feeling him. How many of y'all, Henny Glass in the chat, if y'all seen that compilation video of Trump and Melania, and he's trying to hold her hand and she's smacking it away from him. He's trying to reach for her and she don't want him touching her. Y'all seen them compilation videos? Throw them Henny Glass in the chat, because I know y'all seen them. So they had a relationship, and he's disassociated himself from Epstein, but there's a lot of stuff that's coming out. And I just feel like this, either he's going to make an example of Diddy to show that, hey, I'm not showing any favoritism to anybody who is a part of the 1%. I'm not showing any favoritism to them. Look, listen, I don't like the guy. The guy said some things about me, but, I'm not looking at that. As egotistical as that man is, for good and damn sure he's holding that against him. Let's call things, okay? So he could be making an example of him because of the political views that he's had. because of him talking badly about Trump, or simply because Trump wants to show that he's not showing favoritism. But Jay Clayton seems to be trying to throw him to the mat. Okay? He wants to throw him to the mat right now. That's what is giving in these documents. But I'm willing to guarantee you the defense is not going to take this lying down. They're going to clap back. But you know what I've noticed about both the defense and the prosecution? They like to submit things down to the final wire. Like, they'll admit something at 11:57 p.m. before the deadline passes. You understand? So Clayton is playing a game right along with them. This has been, let me tell you, behind the scenes, if nothing else, the defense and the prosecution, they deserve a TV show. And when somebody decides to make the movie or the Netflix series on that, I would like to play myself. I would like to play myself, please, because I was one of the bloggers that was there in the, down there in the overflow room. I have a New York City press pass. So actually, technically, I'm independent press now. So I have to stop calling myself a blogger. I'm an independent press. That's what I am. I'm independent press. So I'd like to play me, but please make sure that y'all highlight the defense and the prosecution in the midst of all of this. Don't get lost in the hype of the celebrities, because to me, the real tea has been in these documents, baby. The transcripts is tea as well, but the transcripts are old. People don't want to hear about the transcripts because I was supposed to be doing a podcast. Remember, I was supposed to sit there. I was supposed to read all of it, and I was supposed to give y'all the transcripts and all of that. But I don't think y'all want to hear the transcript reads on the Diddy transcripts, because other people have already done them across YouTube. So, and the only way that I will read transcripts if I can give my commentary in between. And that's going to be hard because I've been there. I've been in the courtroom. So I have, But the craziness with all of this, you guys, what do y'all think? Was that a clapback from the government? Like, did the government really clap back? Let me turn this audio down just a little bit. I think I can. Oh no, I can't turn the audio down. I would have to do it from here, because I feel like my audio might be a little too high. Hold on, y'all. If I didn't care. That's why I got this, because I could do that. Let me see something. Hello, is it me or... Hello? All right, is that good? I think that's good, because I think my mic was too loud. All right, so let me just give you a clarification. That text message that I showed y'all, I think Slavic is the one who's running this case now, which I also thought that, does this sound better? Is this a better level for my mic for y'all? Penny glasses, if this is a better level, because I talk loud as it is, so I don't want to be like busting my microphone while I'm talking to y'all. So who's heading this case? I believe it's Slavic. Okay, yeah, this is a good level. Okay, good. Because I feel like when I start talking, sometimes like I be busting my microphone because I already talk loud. I'm from New York. I'm very loud at times. Sometimes I'm very quiet, but other times I'm very loud when I'm talking on this mic because I want to make sure everybody can hear me. No complaints. Good money. All right, so I don't know. What do y'all think? Do y'all think that this is going to Do y'all think they're gonna slam him against the wall? I'm gonna drop the link for those who are brave enough to come up. Because I don't know. This has been crazy, you guys. This has really been crazy. You be busting up the microphone. I do. My bad. I don't want to do that. Like, cause and then sometimes I'll be looking at the little equalizer button and it goes all the way up when I'm talking. And I'm like, okay, maybe I should sit back. She said, this is wild. I agree with you. Okay. I agree with you. This is wild. The SDNY is not trying to take this L at all. Well, technically, let me ask you this, VM, because you're saying that, they're not trying to take an L. Did they really take an L though? Because they still got 2 convictions. So it's not like he got off scot-free. It's not like he was found not guilty on all counts. He was still found guilty. So did they really take an L? I'm not being funny. I'm being for real. It's a serious question. Because I still don't think they took an L all around. They took an L as far as the RICO goes. But I don't feel like they took an L all around. Okay, so VM feels like they took a major L. Sorry, y'all. All right, let's get back into these comments. If they need Diddy for the other cases like Harvey, which I think I see what you're saying, because when the Diddy case was going on, the Harvey case was going on almost across the street. Like, it was down the block in the next building. And like I've told y'all before, there wasn't a lot of press out there. You didn't see a lot of bloggers over there because everybody was over with Diddy. Some of the bloggers did go over there to the trial, and they did go to see what was going on or whatever, but we weren't really reporting on that because everybody was focused on Diddy. And it's crazy because I wish I had like a team set together where somebody could have covered the Harvey trial and I could have covered the Diddy trial, and then we could switch so that we could alternate. And I have a whole thing in my head that I really want to do, but I'm not going to speak about it publicly. As to what I want to work on. But yeah, I'm trying to see what I could do, because if we could have covered both of those cases at the same time, I think that would have optimized everything. But I do feel like, just like with R. Kelly, the last time that Harvey was on the stand for some of his egregious acts, wasn't R. Kelly on trial for that? So I feel like they use us and our people to mask their people. They won and are still winning. Who won? The government? You got to be clear, because I don't know what we talking about. They need to do away with the Mann Act. I don't think they need to do away with the Mann Act, honestly, Mama the Great. And I'm going to tell you why I feel like they don't need to do away with the Mann Act. Because there are still egregious cases. Now, while Diddy's case is not an egregious case, there are other cases that are very highly egregious in act, where people are being trafficked and the Mann Act does apply. Maybe they need to change the name of it. I know they've already changed it from the White Slaves Act to the Mann Act, but I feel like it's still still needs to be in place, but they need to add, they need to set the Mann Act up the way that they have other laws in place. Because this one, it seems like to me, what I'm gathering, because like I said, I'm not somebody who is a lawyer. I'm not a paralegal yet. I am going back to school so that I can study paralegals studies, because I want to be able to help people legally know what I'm talking about, as well as come up here and do my content. I also want to help my son with his case and know what the hell I'm talking about when I'm doing it, and not just trying to figure it out as I go along. So that's something that I feel like would be great for me. I did want to be a lawyer earlier in life, but I just felt like I couldn't do anything in law. I was this street chick. Well, not street chick, but I was out there in the streets. You know what I'm saying? I hung around with a lot of criminals, and I was just like, okay, I could make money by defending them. Yes. But I just didn't want to have anything to do with the law. Okay. Plus, I felt like I needed money on the table for my kids, and going to school at the time wasn't going to do anything. Child, it's a long story. But anyway, I've always had a passion for law. And I think I get that from my dad, and I get that from my mom, because my dad was a jailhouse lawyer. Okay, my dad could get you off your charges with using your regular court-appointed attorney, because he'll tell you what to tell your attorney to do. And he's done it. And that's why a lot of people loved my father and respected him a lot, because he helped a lot of people with their cases from behind bars, outside of bars, all of that. Anyway, but where was I going with that? I lost my train of thought. Anyway, I just feel like the Mann Act doesn't need to be done away with totally. I don't. I feel like they just need to structure it better. Okay. And they also have put into place the Mann Act, where it does go after people who are customers of this. Now, again, I am going to say this before I go on to the next comment. While Diddy's case is not egregious and heinous like we've seen in the past, where there's been children who have been trafficked and used in prostitution, which would be the Mann Act, right? They also have there's a lot of stories. If you go into watching and digging up things on that, if you're into it, then you'll know what I'm talking about. There's a lot of stories of people who have survived being trafficked and put into prostitution. Sex trafficking and the Mann Act go hand in hand. And the stories that they tell are highly egregious. But on paper, it's so vast, right? That's what we're learning. It's so vast that anybody could catch a Mann Act case. So yeah, I see where you're coming from, but at the same time, I do see a purpose for it. Only if he gets less than 3 years, it's major. All right. They schedule the trials simultaneously by design. I'm just saying, I'm with you on that. I'm with you on that. Trump has said if they deny him bail, he's more than likely to pardon him before sentencing even takes place. Where did you hear that at? Because I haven't heard anything from the White House saying that. I did read a piece that came from Deadline, and I don't know how credible Deadline is as a publication, but they were the ones who were talking about having administrative sources, and sources are saying to them that this is what Trump is considering. But at the time of publication, there hadn't been anything. And all day yesterday, I didn't hear nothing from the White House stating that this was even factual. So I don't know where that's coming from. I'm not saying it's not true. I'm not saying it is true. I'm just saying I don't know the source. You know what I'm saying? So I don't know if that's true or not. They already got Oprah snitching on Harvey. I don't think they need Diddy. I like that idea. You like that idea? Thank you, VM. What about his business partner and vice president of Bad Boy? Who are you talking about? Harv Pierre? Because Harv Pierre has been named in a civil case right along with Diddy. See, that's the other thing that people aren't remembering. There's a lot of civil cases that are still out there for Diddy. And I'm not talking about the ones that came from Tony Busby, because baby, y'all already know how I feel about Tony Busby. Okay, y'all know how I feel about Tony Busby. Y'all know how I feel about Tyrone Blackburn. Let me tell you, whenever a Diddy case comes down, the first thing I do is scroll all the way to the bottom, because I want to see who is it that signed off on this. And if it is Tyrone Blackburn or Tony Busby, I side eye it. I'm not going to hold you. I'm so for real. I don't trust neither one of them lawyers. And anybody who's using them, I question your judgment, especially when you hearing people coming out talking about Tyrone Blackburn be lying, be exaggerating the story to try to get it to trend. If there's an egregious act that happened, let the egregious act just be that. Don't add to it. Don't take away from it. Don't water it down. Don't spice it up. Leave it as it is. Because see, then when you get down to trial and things start getting picked apart, then things start looking funky and funny. You feel me? Let's see. His supporters are the ones who think it's a major L. Well, I mean, his supporters, but there's also some people, legal experts and things like that, that feel like it was a major L. There's some news outlets, even though there are some major legacy news outlets that have been completely biased. Like, I've watched legacy media report, and it's no knock, no shade to them, but I've watched legacy media report and not say when the defense has done an excellent job on that day. I've watched them sit there and also spin stories and narratives as well. Over here, I haven't spun narratives or stories. I've given y'all straight up facts from what I've seen, what I've heard, and what is backed up by the transcript. 9 times out of 10, when I've come on here and I've said something to y'all, I can go back into a transcript and read it to y'all, and it's damn near verbatim about what was said in the courtroom. So I haven't lied to any of y'all. I just don't hold the same passion, so to speak, as other people do. And let's be very clear, when I start talking about glizzy gobblers, I'm talking about those people who have not been down there. When I'm taking my shots at people, it's people that have taken shots at me, that are content creators that have not been out there at the courtroom at all. Even some of the people in the comment sections, y'all was not out there, but then y'all decide y'all want to try to come for me on my channel in my dojo, and you think I'm going to sit back and let that happen? Baby, let me tell you something. I will clap back at you so hard. And today is fucking Friday, so y'all can go in on whomever if they come up in here, trying to act like they, hold on, because you doing a little bit too much, baby. You doing a little bit too much. Okay. They need to take a better look at it and change some things. Yes, honey, we on the same page. The government won and is still winning. The judge is not playing either. Oh, okay, that's what you were saying, that the government won and is still winning. You can still go to law school as well if you want. I don't know about being a lawyer though. I would love to, but that's a lot of years, and I don't know if I could actually do that. Like, I'm gonna tell y'all how old I am, because I don't give a damn. Okay, I made it to this age, and there's a lot of people that I know that did not. I'm 46 years old, y'all. So I feel like, then I keep hearing people saying, nah, people be taking off at 40, 50, 60. They be, people becoming millionaires at that time. So I don't know. Y'all think I would be a good lawyer? Y'all let me know down in the comments. Y'all think I would be a good lawyer? You'd be a great advocate as a lawyer or pilot. Oh, thank you so much. I appreciate that. I think that they thought that since Comey was gone, it was going to be to their advantage. Probably. I'm not so sure. I believe based on Trump's previous remarks on this case, he would pardon Diddy. Like I said, I'm not against anything, and anything is possible at this point in time. For all we know, Trump could sweep in right now and be like, you know what? I'm sick of the back and forth with this case. I'm sick of us spending money on this case. Just pardon him and get him out the way. But I also think Trump wants this to continue to go on, because as long as this continues to go on, there's a distraction from Epstein. But let me just let y'all know, I'm not distracted. I have been keeping up with Epstein. I just haven't reported on it because it didn't do too good on this channel when I did. So, you got violent criminals out on bond. That's true. You do have some violent criminals out on bond, and guess what? I don't agree to that. I don't agree to anybody who commits any acts of violence against another human being out on bail, because you've already shown yourself to be a threat to community. So I don't understand that. And I also know that there's been cases where people have unalived people and they get out on bail too. I don't agree with none of that. So understand this. I don't agree with anybody who has a violent history of doing anything. They're on trial at the moment. They are in court for a violent offense. I don't believe they should be even given a bond. I think they should be held. But the difference here, Tiger, is that the judge put a mandatory hold basically on him. And he is holding Diddy under what is called a Chapter 17. Thank you for that, because you reminded me. We are supposed to be... I spelled that all kinds of wrong. Okay, so let me bring this up on the page for y'all. Let me share this. Okay. So 18 U.S. Code, Chapter 117, Part 1, transportation for illegal sexual activity and related crimes. So that's what the 117 is. Okay. I'm sorry. I was reading through this to see which one. I guess that would be the one that they're going to, or are they going under coercion and it's site? I don't know. I don't know if that's what they're using it under or not, but we wanted to see what that actually was, and that's what it is. U.S. Code Chapter 117, Part 1, transportation for illegal sexual activity. Now, let me see. Hold on one second, y'all. Let me see if I could find the portion that he used. Okay. Let me see if I can see this on here. 117, right? And we're going to see which paragraph, subsection, all of that stuff they used. Okay, hold on one second. Let me go here. Let me... Because I want to know what it is. I want to know what they're actually charging him with. I wish this would have opened. You know what? Let me just download it and open it in my damn Acrobat, because I don't know why this thing is in this type of a document. Like, I don't know. The documents have been weird. They've been really weird lately. All right. Nope, that's not the one that I want. Oh, God. All right. Okay, there it is. All right, let's see if we can get to that. All right, so I don't see under Chapter 17. They just keep saying under Chapter 17. And then they're saying U.S. Code. Here, let's see if I could drop this in there and see what some of this is. We gonna learn today. I know some people is gonna check out on us, and that's fine. They can check out all they want to. Okay. Let's see. That's not it. So that's 18. Let's see. And this is how you guys can look this up for yourself too. Okay, so I did something wrong. All right, it's fine. Okay, let's see. Don't be coming for me neither, okay? Because I told y'all I spelled it wrong because I was typing fast. I don't care. Y'all could come for me all y'all want to. Okay. U.S. Code subsection 3143, release or detention of a defendant pending sentencing or appeal. Okay. It says, except as provided in paragraph 2, the judicial officer shall order that a person who has been found guilty of an offense and who is awaiting imposition of execution of sentence other than a person for whom the applicable guideline promulgated pursuant to another code does not recommend a term of imprisonment be detained unless the judicial officer finds by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or community if released under subsection 3142B or C. If the judicial officer makes such a finding, such judicial officer shall order the release of a person in accordance with the section. So that's what they said, that they can release him under that. It says that the judicial officer shall order that person who has been found guilty of an offense in a case described in paragraph A, B, or C of subsection F1 of section 3142 and is awaiting imposition or execution of a sentence to be detained unless the judicial officer finds that there is a substantial likelihood that a motion for acquittal or new trial will be granted. So it says that a person who has been found guilty of an offense, okay, and is awaiting imposition or execution of a sentence is detained, meaning they're held. They're held unless the judicial officer finds that it is substantially likely, it's a substantial likelihood that a motion for acquittal or new trial will be granted. Now we're seeing where the defense is going with this. We're seeing where they're going with this because it says if there is a likelihood for that a motion for acquittal or new trial will be granted. And that is what Shapiro just came with, right? We just saw her drop that. We read it yesterday, all right? An attorney for the government has recommended that no sentence of imprisonment is imposed on a person. So the government can say, we're not going to, there's no sentence of imprisonment to be imposed. Okay, the judicial officer finds by clear and convincing evidence that the person is not likely to flee or pose a danger to any other person in the community. So, yeah. Release or detain pending appeal. Now, they're not pending an appeal. Okay, release or detain pending an appeal by the government. That's not the case here. So that is exactly all of that we just read, especially this right here. That to me speaks volumes as to why we got what we got yesterday. Why we got that letter from Alexandra Shapiro that was saying to us, or was saying to the judge, well, we would like an acquittal or a new trial. You're going to give us one or the other. And if you give us one or the other, then you have to release him. You see how that goes? How that goes? Did y'all just pick up what was put down? By reading that's the play. So we're going to ask for bail. And even though the judge has said, I'm not releasing him on bail because, number one, he has not clearly and convincingly showed us any proof that he is not a threat to the community or any specific person. He's also not proven to us that he's a flight risk. And his propensity for violence, all of that is why he stays in jail. But if you go off of this right here, if you go off of what I just read, which is what they've been referring to, 18 U.S. Code subsection 3143, when you get down to it, if there's a likelihood, if there's a substantial likelihood that they're going to grant an acquittal or a new trial, then they have to release him. So remember yesterday I said that they gave the judge 3 options. Either you're going to give him bail, you're going to acquit him, or you're going to give him a new trial. This was the secret weapon right here. Because if he's going to do it, he's got to release the defendant. You see why I said we're going to learn something today? This is why I said that. Okay, this is why I said that. Now we're going to take this one and we're going to look this one up too. What, did y'all learn something today? Did y'all learn something today? Is that a double S or a 1S? I think it's a double S. And we're going to drop that in there. Now this is 42. All right, this is the other one. Upon appearance before a judicial officer of a person charged with an offense, the judicial officer shall issue an order that pending trial the person be released on personal recognizances or upon execution of an unsecured appearance bond under subsection B of this section, released on a condition or combination of conditions under subsection C of this section, temporarily detained to permit revocation of conditions, conditional release, deportation, or execution under subsection D of this section, detained under subsection E in this section. So now what are they looking at? They're looking at A. It's 1A. Okay, release on personal recognizances. That's not going to happen. Release with conditions. These are all of the things that Mark Agnifilo put in there. Okay. Personal recognizances, they asked for that, or an unsecured appearance bond. They trying to put, that's what that 50 million is for. Okay. Released on conditions. That's where they're putting in electronic monitoring and all of that stuff. So this is where we're starting to see a lot of the, defense's motion come into play, right? And this is why they said that the defendant's Mann Act convictions are such felonies when it comes down to chapter 17, and they say 18 subsection 3156A 4C. Let's go there. And it's only 1S. Let's go there and see what it is that the government is talking about. Any glasses in the chat if y'all learning today? If y'all are learning today. Okay. As used in subsection 3141 through 3150 of this chapter, the term judicial officer means otherwise, unless otherwise indicated, any person or court authorized pursuant to section 3041 of this title or the federal rules of criminal procedure to detain or release a person before trial or sentencing or pending appeal in the court of the United States and any judge of the superior courts of the the District of Columbia. Okay. So where are we? We are at A4C. A4 right here. The term of crime of violence means, and we're at 4. We're in section A, and we got to drop down to C, which is right here. Any felony under chapter 77, 109A, 110, or 117. So we go to, we're in 4, and we read 4A. An offense, this is what it is. An offense that has an element of the offense an offense that has an element of the offense to use, attempted use, or threatened use of physical force against the person or property of another, and any felony under those chapters is what we're looking at when we're talking about the term crime of violence. Okay, so that's how you would read this. All right, so you go to 4, which is the term crime of violence and what it means. You go to A because that's what they're talking about in the document, A. There it is. And then here is C, which also adds to it. So when you put all of that together, this is what they are charging under 117, which is what? The transportation. This is how they put all of this together. So we can go back to this. We can go back to chapter 7. My bad, y'all. Let me pull that back up for you guys. Okay, so we're going to go in here and we're going to go to chapter 17. I'm sorry, 117. All right, right. They're saying under chapter 117, transportation for illegal sexual activities and related crime. So when it comes to chapter 17, when it comes down to transportation for illegal sexual activity and related crimes, they're referring to also this crime and saying that there is a crime of violence. Okay, and this is the offense. This is how they're tying all of this together. You see that? Henny Glasses in the chat if y'all learned something today. So now we understand that under the transportation for sexual activity, he's convicted of that with crimes of violence. Now the defense has come with their two motions for bail and asking for an acquittal or a new trial, because they're banking underneath him being released under the likelihood that he would be granted either of those two things along with the bail. So what they did was a double whammy of trying to get him out. Does that make sense? Does that make sense? Like, did I explain that good to y'all? Because I just showed y'all how I'll be piecing it together. That's how you figure it out. Now, what y'all talking about down here in these comments? Thank you for the super sticker, Xavier. Oh, thank you, Yvette. She said, great lawyer, maybe paralegal field. Thank you. Hey, Sins. Fountain of youth. Get rid of negativity. I'm in witness protection program. Can't show my face. Oh, I shouldn't have put that up there. I'm sorry. Oh, y'all let me know where the Fountain of the Youth at. Y'all can't be cuffing the location. Girl, our age is the new 30. LOL. I'm 47 and you look good. So do I. Age, not a thing. Keep pushing. Thank you. And I don't have no filter right now. Why do you keep calling him Duffy, Miss Perry? Duffy is a violent criminal. Okay, 46 years young. You could defo represent me. Oh, thank you. You look like you 36. Thank you. Now Diddy can claim it's a hoax set up by Comey. You said do it. Find an online law school near you. A liar, not a lawyer. Who is a liar and not a lawyer if you are still in here, Tiger? You probably bounced up out of here a long time ago. Troll. Thank you, Black Gold. I love your profile picture. You could finish in 4 years. 4 years what? A paralegal? Because I sure can't do it for law school. Thank you, y'all. Wait a minute. MEP, what's popping? All right, let's see. A lot of Henny glasses. So y'all definitely learning something. Okay. That makes sense. Oh, I'm glad. I'm glad it made sense. Yes, I understand it. I'm glad. I'm so glad that y'all understood that. The prosecution and the defense going harder on the bail than they did in the trial. Bianca, do you hear me? This is why I said these documents are tea, honey. They are tea, and we are all up in them. We're gonna stay up in them, okay? But you know, I'm getting back to my basics of how I do things and entertain y'all. Are y'all not entertained? Do y'all not feel entertained and educated? Cause y'all learned something. Okay, y'all learned something. Moonlight Sunshine, we already know how you feel, girl. But you wanted a Henny gang, so you know. We not gonna get you because you wanted a Henny gang. Not only that, you know, that everybody is entitled to how they feel. You know, some people want them out, some people want them in. I'm just saying, I'm looking at all of the drama of it all, baby. Let's get back to the drama because this is tea. This is tea. You cannot deny. If I were to read I read some of Shapiro. Now, if they come in with another document, I'm going to read it all with just as much dramatic flair because I don't want y'all to miss none of this. And I'm going to try to break it down the way that I just did with them couple of codes that we did. We was able to figure out what they was talking about because normally we be reading it like chapter 117. Okay, whatever the hell that is. Subsection this. Now, okay, whatever the hell that is. But let's actually look at it and see what it is so that we can all see for ourselves and piece it together. What are they trying to say to us in these codes? It's like they be talking in code. What'd you say? Maxwell and Diddy released on the same day reaction. Girl, Shannon, don't do it. Don't come in here speaking no hexes over this chat. They no, in all seriousness, they need to keep Ghislaine's ass for real, for real. Now that one I'm gonna be vocal on as hell because I've been digging in all of that stuff. Her ass need to sat down. Okay. She said, you know, I got a razzle dazzle. Shannon, you not funny. We not laughing with you, girl. You will have us stressed out. I think all my hairs would turn gray. I'd be in here looking like Diddy. Y'all will be like, damn. Henny hair done went from black and burgundy or whatever this color want to be to white. White and pink. I will be so stressed out if they release both of them. But the thing is, with Ghislaine, Congress ain't want to hear what she had to say. I just knew for a fact that they was going to want to hear it. They said, we don't want to hear nothing you got to say. Nothing. Okay? Nothing, Jesus. Nothing. All right? What you said, Miss Pammy? I'm being entertained in Edgar Med Cad. And yes, I said the Edgar Mike paired. I don't know what you're saying. You're speaking in code to me. Just don't go bald like someone. I will not be Carlista Bold, okay? Bald. I will not. VM, if they release Ghislaine and Diddy at the same time, how you gonna feel about that? Y'all tell me how y'all would feel about what Shannon just came in here trying to speak into the universe. Girl, we rebuke that. I think we all agree, keep Ghislaine. We can fight over Diddy, but keep Ghislaine in there, okay? Andre, we know how you feel, baby. We know how you feel. Oh, see, everybody's saying keep her in. No, lock her ass up. That's terrible. We are terrible. We are terrible. Educated, but I was trying to say in the bubonic way, damn Siri won't do it. She changed everything else. We rebuke Satan. Y'all are a mess in these comments. But listen, I love y'all very much and I appreciate y'all. Now I know that I'm trying to think. No, I need to take a break because I done been on here since 9 something. Y'all done got like 2 hours and change up out of me. I need to learn to take a break and take a breather. But I have other stuff that I'm going to bring out. Now, if I'm going to bring it out on a live, I don't know. I may just sit and record it. But either way it goes, y'all be looking out. I will premiere any recorded videos so they're like a live where we can all be in the chat together. You can go and notify once you get a notification, or you come and check to see. But I have other cases that I want to talk about, other topics that I want to talk about. And we're also going to get back into reviewing content and talking about the little gossipy stuff like Cardi B and Ra Ali. We're going to go back into talking some of that stuff because we got a little too serious after the Diddy trial. I got a little too serious. I'm not even going to hold y'all. I started feeling like I had to change the way that I was reporting things and make my channel all serious and stuff. No, that's not what y'all came here for. Y'all came here because y'all want to hear me go in. Did my phone fall? It sure did. I'm looking, I'm seeing the lights flashing. Hold on. I thought that was my son. I thought that was my son. I was about to say, you want to talk to my son real quick? I will try. I can't promise. Okay, free puffy, mix and match. And exactly, I was never one way. I mean, I read court docs, but I also did other content too. So I need to get back to my basics, okay? We got to have some more live you. Y'all love to keep me live. Y'all love for me to be on this doggone live. I like to be on the live with y'all. I'm not going to hold y'all, but I got to start doing other videos because like yesterday was Apple Juice's birthday. So while I was out celebrating her birthday with her, I could have had videos dropping for y'all if I would have sat my butt down and recorded. So I think with me starting to get myself up early in the morning, like how I was doing for the Diddy trial, that's going to help me with a lot of this. I got away from using baby oil. Let me see if it's in my book bag still. Oh no, I took it out. I'm never going to give up my baby oil. Baby oil keeps my skin nice and soft, and I want to keep it nice and soft, okay? So I'm still going to use my baby oil, baby. Diddy ain't take that away from me. But anyway, I had something. Henny, you're pretty and funny. Thank you very much. I appreciate that. So yeah, we're gonna get back into that, but I definitely have to get myself in the habit of stuff. So I'm getting back to what made y'all fall in love with me in the first place, okay? But before we go, I would like to offer these to Diddy. Diddy, you may not know what these are, but these are old school whorehouse coins, okay? These are old school whorehouse coins. See, it says best screw in town, all right? It says whiskey, tobacco, and fancy women, okay? This one says best young ladies in the West to serve you, okay? Here we go. All right, these are whorehouse coins, all right? One first class lay. All right, here you go. These are for your use. Okay, this is back in a time when you could walk up into a saloon and you gave these coins to get a lay. And since you like to hire prostitutes, I figure if I give him these coins, he should be okay, right? Like he should be able to use it. Any glasses in the chat if I should get these to Diddy? What y'all think? And see, he got different places that he could go. See, it says wide ass Nelly. Look, it says, y'all can't see it because it goes backwards, but it says wide ass Nelly on there. Okay? Okay? Proprietor. All right? This is in Adobe Concert Hall. Satisfaction guaranteed. This is in Nevada. Okay? All right. Then you got check-in guns at the bar. Anyway, all day. All right? This is at the Hog Ranch. Good for a $2 piece. Look at that. Look at that. That's when hoes was $2, y'all. It was only $2. What's the price for hoes now? It used to be $40. But Diddy done up the ante. All right. Then you got Mahogany Hall in New Orleans. Room check, good for all night. World famous sporting house. Okay. Look, see, New Orleans. I'm giving you places you can go and spend these at. Okay. Okay, good for one piece. San Francisco. Compliments of Diamond Little. Okay, and they say they got the best screw in town. So you see, these are good to be spent other places. Okay. Should I give them to Diddy? I don't know. Listen, it's legal currency. It's currency for it. See, if you spend that money, they can't get you. Okay, they can't get you because those are whorehouse coins. Anyway, I'm about to go, y'all. It has been wonderful chilling with y'all this morning. May the rest of your Friday be highly elevated. Remember to vibe high so that the bullshit don't stick. Love is always love, and I love y'all. And I'll see y'all in the next pour up. Peace, everybody.